major change was that clause 4 to article 13 was inserted, which speaks that nothing in this article shall apply to any amendment of this constitution made under article 368. And the third change which was made was incorporation of clause 3 in article 368, that nothing in article 13 shall apply to any amendment made under this. So these were the three changes. Because Golaknath had absolutely made the parliament incompetent to amend any or every part of the constitution. So the parliament right away came with the answer in terms of the 24th Constitutional Amendment Act 1971. Now, this very Amendment Act was put to test insofar as the constitutionality of the amendment is concerned. Now, this amendment was put to test in the landmark case, as we all know, of Keshwananda Bharti versus State of Kerala 1973. Now, this very judgment had upheld the validity of the 24th Constitutional Amendment Act. The judgment and the import, what was captured in the Golaknath versus State of Punjab, whereby the Parliament's incompetence, that was overruled. The 24th Constitutional Amendment Act was held to be absolutely valid. But there was a historical, you can say it's a historical day, as we could see a judicial innovation in this very judgment, wherein while upholding the validity of the 24th Constitutional Amendment Act, the Honorable Supreme Court came up with what we all know today as the doctrine of basic structure. The doctrine of basic structure is a judicial innovation. It is not provided anywhere in the Constitution. It is a judicial innovation in the case of Keshwananda Bharti versus State of Kerala. Thereby, while upholding the 24th Constitutional Amendment Act, while upholding the factum that the Parliament enjoys both the constituent lawmaking power and the legislative lawmaking power, the Honorable Supreme Court of India came up with something that is called as the doctrine of basic structure. It's an absolute judicial innovation. Doctrine of basic structure is ever evolving. It is not that what was innovated in the 1973 judgment was an end to it. It's ever evolving. The salient features from time to time have been brought within the ambit of doctrine of basic structure. So the Honorable Supreme Court says that the Parliament is competent to amend any and every part of the Constitution, including the fundamental rights. But any such amendment which contravenes the doctrine of basic structure would be declared to be unconstitutional and void to the extent of such amendment. अब doctrine of basic structure में क्या है? As I at the very beginning was reading the preamble, I will read it again. These are the salient features, salient aspects of the Constitution, which run through and through the Constitution. It says, we the people of India, having solemnly resolved to constitute India into a sovereign. Sovereignty of India as a principle is part of the basic structure. Socialist, secular, secularism. As I said, that basic structure is ever evolving. Secularism was held to be part of the basic structure in S.R. Bowe versus Union of India 1994. Democratic, free and fair elections, balance among three of the state, they are all parts of basic structure of the Constitution. Republic. So the scheme, the salient features of the Constitution that run through and through are part of the basic structure. Supremacy of the Constitution, federalism, they are all part of the basic structure. Free and fair elections, the doctrine of welfare state, they are all parts of the basic structure. So it is not that doctrine of basic structure once created had attained its end. It is ever evolving. As times warrant, whatever is the want of the time, if it is consistent with the salient features of the Constitution and ought not be contravening the salient features of the Constitution, has to be part of the basic structure, which time to time has been made by the Honorable Supreme Court. Now, the Parliament did not stop here. The the doctrine of basic structure came in 1973 was to be answered. And the Parliament of India came up with the 42nd Constitutional Amendment Act, which is also called as the mini constitution, because a number of amendments had taken place so far as the constitution is concerned. But we are, as of now, only concerned with what was the answer in terms of the doctrine of basic structure. And otherwise, this doctrine of basic structure is based on the Weimar Constitution. In Germany, it is the eternal structure on which the basic structure is based. So the Parliament subsequently enacted the 42nd Constitutional Amendment Act. Now there were certain changes which were introduced. Clause 4 and Clause 5 to Article 368 were introduced by way of the 42nd Constitutional Amendment Act. Now what is the 42nd Constitutional Amendment Act and by virtue of which Clause 4 and Clause 5 have been introduced? I would read Clause 4 of Article 368. It says, no amendment of this Constitution made or purporting to have been made under this article shall be called in question in any court on any ground. So the Parliament says that if an amendment to the Constitution is made or purporting to have been made under this article shall not be called in question in any court on any ground. So the Parliament's intention here are to make the power absolute. But constitutionalism captures the doctrine of limited government. And in a country where separation of powers, though is not watertight, but exists to an extent that no organ shall infringe over the other organ, this amendment ought to have been challenged. There was another change. That was introduction of Clause 5 to Article 368, which further says, I will read for you, for the removal of doubts, it is hereby declared that there shall be no limitation whatsoever on the constituent power of the Parliament to amend by way of addition, variation, or repeal the provisions of this Constitution and this article. So in the Constitution itself, the Parliament introduces the 5th clause under Article 368, whereby they say that there is no limitation. That would overreach prima facie and would surpass the doctrine of limited government. Because the balance among the officers of the state is the essence of the Now this amendment again was put to test before the Honorable Supreme Court. This amendment was put to test in the case of Minerva Mills in 1980. The Honorable Supreme Court of India, in the Minerva Mills judgment, right away had struck down Clause 4 and Clause 5 of Article 368 and held it to be unconstitutional and void. Again, for the reason because absolute power has no standing in democracy. In Minerva Mills versus Kingdom of India 1980, what evolved was that judicial review is also part of the basic structure. As I told you, that basic structure doctrine is